charged with one or more misdemeanor offenses. This morning, we have a motions calendar in which in most cases, the defendant has filed particular motions to address, and the state is going to find out if they're ready to proceed, especially with their officers. So I'm just going to do a brief roll call to get the status of the cases, and then we will proceed accordingly. If you are a defendant appearing on Zoom, do we have any defendants or clients in the hallway that you know of?
I can check it out.
Please, Mr. Stevens, thank you so much. Do we have a motions calendar also, by any chance? I mean, a bench trial calendar, I see more attorneys out there.
Here is, honesty has not been good to us since the update.
No.
So we only have one for this afternoon.
Right. All right, so I was saying, if you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent about the facts of the case. Any comments that you plan to make about the case or statements can and will be used against you. And you have a right to an attorney. If you haven't, if you can't afford one, I hope you have retained an attorney. Otherwise, you can waive your right to counsel and represent yourself. Position number one, Janelle Lukens, represented by George Creel.
Good morning, Judge. I'm here, Miss Lukens. I don't see her on the screen, but we've spoken and she should be logging in. So I'll check with her and see what's going on.
All right. Yes, Ms. Waldrop, you want to say?
No, Your Honor, I thought he had a conflict in the CAD based on what was filed. I was just gonna make that announcement.
Okay. And your officer is ready for the motions?
Your Honor, we have argument prior to that. The state is ready.
Okay. And can we adjust the microphone so Ms. Waldrop can? Is it?
Yes, Judge.
All right. So
What was the state's announcement, Judge?
go ahead, Ms. Waldrop. I don't think he heard you.
Yes, Your Honor. Prior to, we have argument on the motions, Your Honor, but the state is ready.
State has a motion for some argument that I'm not privy to, but we'll find out as soon as we address your case. All right?
Okay, Judge.
Eduardo Medina, attorney Christopher Howard. Do we have something going on in that case I don't know about?
Your Honor, I have not heard from Attorney Howard. I can try to reach out to him. If the defendant does not show, obviously, we would request a bench warrant.
Okay. Quincy Navabude. Quincy Navabude, Julie Kurt. Have an entry of appearance. Motion suppressed by Ms. Kurt. All right.
Yes, ma'am. My lawyer told me to say that she got held up on another, she had court at 8 o'clock, that she'll be in shortly.
All right. You need to put on your video so I can see who's talking.
Yes, ma'am. Yes.
Okay.
And Your Honor, the state and defense have reached a agreement in that case. That case would be a plea.
Will be what?
That would be a plea, Your Honor, once a attorney gets on the line.
All right, Mr. Nawabude, I understand that your attorney is going to be showing up later, and we're going to take a plea in your case. So I'm going to hold for her appearance, and as soon as she appears, I will take the plea hearing accordingly. Okay? So do not leave the Zoom. You can switch off your video now, but do not mute your Zoom. But make sure you're not too far from the device so that when we call your case, we are ready to go.
Yes, ma'am.
Thank you very much. Mohsen, Mr. Willis, you're here for Mohsen. Last name begin with an S.
Yes, Your Honor. I'm here standing in for Mr. Mark Hansford on that case, and that case is ready for a negotiated plea this morning.
All right. Mr. Glanville, do we have a Mr. Mohsen? Can you hear me? All right. The person who is assisting them with the iPhone, could you please unmute? All right, I don't know if they're listening. The person who is assisting Mohsen, could you please unmute? Mr. Glanville, any status on the Farsi interpreter? All right, we're gonna hold for that announcement.
I was unaware there was an interpreter request for today.
We'll need a, Mr. Mohsen, could you please unmute? We look at the case, I want to make sure. All right, just look up that case and let's see if the request was timely made, okay? And then it's your case, Mr. Willis, Chad Zoretic.
Yes, Your Honor, we're here on that case. We got some preliminary matters to take up as it relates to discovery and lack of discovery and late discovery. So we're going to need a hearing before we can announce ready or not ready on that.
Ms. Waldrop, Mr. Stevens?
That's my case, Your Honor. The officers are here, ready to proceed with any and all preliminary motions.
All right, how many officers are we talking about? You use plural.
Yes, Your Honor. We have 2 officers that are currently here. We also have 1 other witness toxicologist who is on her way, should be here within the next 15 to 30 minutes, Your Honor.
Okay, 3 witnesses for the state. All right. Looks like I'll be proceeding with position 1, position 5, and then pleas for position 4 and position 3 and question position 2. Mr. Nagel, good morning. Sir, which case do you have?
Good morning, Judge. I represent Brianna Alston. That's a negotiated plea.
Okay, and is Miss Alston present?
Judge, I see her. Miss Alston, can you turn on your sound and camera, please? There we go.
All right, excellent. All right, let me go ahead and begin with the plea of Miss Brianna Alston, and then we'll wait on our interpreter. And then meanwhile, we will then move on to Mr. Crale's matter, and then we will move on to Mr. Willis's, your 2 matters. I have a gentleman in the courtroom, sir. What's your name, please?
Chad Zoretic.
Oh, I see. Okay, got it.
He's here with me, Your Honor.
All right. Miss Brianna Alston, if you could please raise your right hand. For purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, it's the truth to my knowledge.
All right, thank you. This is State of Georgia versus Brianna Alston, accusation number 22 CR 0000347F. Ms. Alston was accused of failure to use a proper signal and failure to report, hit and run, failure to stop or return to the scene of the accident. And this was from a November 11, 2021 incident. Ms. Alston, you've been advised of your right to remain silent, and your attorney is Mr. Tom Nagel. This is going to be a negotiated plea hearing, so we are first going to hear from the prosecution.
Yes, Your Honor. The defendant is pleading to 1 count of failure to signal lane change or turn. On that count, the negotiated sentence is for 12 months probation for the defendant to pay a $200 fine. And then it's also pleading to 1 count of failure to report an accident. And the negotiated sentence is 12 months, credit for time served, balance probated, for the defendant to pay a $300 fine, complete defensive driving, and 40 hours of community service. Those counts were to run concurrent to each other, and we did agree that probation could terminate upon completion of all conditions.
Mr. Nagel, are those the terms to which your client has agreed, and do you stipulate to the factual basis, venue, and ID for these 2 offenses?
Yes, Judge, we'll stipulate to a factual basis, and that is the negotiated agreement that we've reached.
All right. Ms. Alston, have you consumed any medication or alcohol recently?
Yes, I did.
All right. And after doing so, well, which one, medication or alcohol?
Both.
I mean, today?
No, not today.
All right. Well, that's good to know. And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And after discussing the issues and the consequences and options, are you excuse me, are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Do you understand that if you enter such a plea to these two charges, that you will not have an opportunity to a trial? You will not have the assistance of counsel to come back, face a judge or a jury in order to have a trial, confront your accuser, challenge the evidence and the witnesses brought before you, have the opportunity to cross-examine witnesses and present any defenses if you choose to do so, and have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to failure to signal a lane change and a failure to report?
Guilty.
On the failure to signal a lane change, your sentence is 12 months probation to pay a $200 fine. For the failure to report, it's 12 months credit for time served, balance probated, to pay a $300 fine, complete a defensive driving program, and 40 hours of voluntary community service at any nonprofit agency. You may complete the community service at any organization that is a 501c nonprofit agency, as long as it's not a school and not a church.
Yes, ma'am.
All right. Mr. Nagel, have any of the conditions been satisfied, like defensive driving?
No, I do not believe they have been yet, Judge. They need to be done on probation.
Okay, Ms. Alston, you will report to probation, and that would be next Thursday, which will be the 28th of September. And you will report to probation before 3 p.m. The location is 132 Mitchell Street in downtown Atlanta.
Judge, will I be getting that in the email?
I don't understand the question. Would you want?
Will I be getting that address in the email?
You will be getting the address from your attorney.
That's correct.
Okay, thank you.
Do you have a pen and paper? You can write it down right now.
I don't, but okay.
I'll
thank
send
you.
it to her, Your Honor.
All right, before 3 p.m. next Thursday. And once she's on probation, she needs to make sure she pays the fine, completes the defensive driving, and completes the community service. She will report every month. She will pay probation fees every month. So the sooner she's done with the conditions, the sooner she'll be done with probation. And that would terminate upon completion of all conditions.
Thank you, Your Honor.
Any questions, Mr. Nagel?
No, Your Honor, it's clear.
All right. Thank you, Ms. Alston. If you have any questions, you can contact the clerk's office or reach out to your attorney.
Thank you, Judge. Have a great weekend.
You too, sir. Thank you. Thank you. All right. Mr. Willis, Mr. Mawson has still not been able to unmute. So,
Let me step up and call Mr. Hansford.
okay.
I don't even have a
And
contact.
then just confirm if it's a Farsi interpreter, but that's what I'm just gauging by his name. I don't want to be accused of stereotyping, but you know,
Understand.
I'm just gauging by the name. I believe is Farsi.
Okay, let me call Mr. Hansford.
And if you can also ask him how he sent in the request for an interpreter, because I don't see one in ours.
I think he was thinking that the gentleman with him was gonna do the interpreting is what I understood.
Oh, okay.
So I shouldn't, is the interpreter request still necessary?
We need the Farsi interpreter. We can't use the friend. All right. While we're waiting for Mr. Moson's case, Ms. Kurt has not appeared yet, so we're going to move on to Janelle Irene Lukens. Mr. Skrill. I think he
Yes,
was.
Judge.
There he is. Okay.
Yes, I'm here.
Oh,
Yeah, Ms. Lukens is here.
Lukens is present as well. Okay, Ms. Lukens, you can go ahead and start your video, please.
I have. I'm not sure why I'm not. Can you see me?
No, you have to probably leave the Zoom and make sure that your device is your device is connected to the video and audio of your device. Or if you're using one of those little attachable cameras, it's not the Zoom is not connected to the camera.
Okay, I'm going to exit and I'll be right back.
All right, Mr. Creel, shall we wait for her?
Yes, Judge.
Okay.
Well, we don't, I mean, we can hear the state's arguments, and my understanding is they didn't have evidence, they have argument only, so if they have an argument, let's hear it.
Ms. Waldrop, are we ready to proceed? Did you?
First, I'm just trying to get clarification. Was this not an in-person hearing?
It was. Yes.
I didn't understand that. I just got a Zoom notification.
I honestly can't remember. Let me look at my notes, okay? Typically on motions calendar, they're always in person. So,
Well, we can reschedule it for in person, but I mean,
no, I'm not rescheduling. I can wait for you all to come down. I'm here all day.
my client's not in Georgia. She's in her family's house in Ohio or something. And I'm on another Zoom hearing as well in Magistrate Court in DeKalb. So we'd have to ask for a continuance if you want us to come in person. But my understanding is the state doesn't have any witnesses there anyway, so.
Let's just go ahead and hear your motions, your arguments, because otherwise we can be rescheduling this till infinity.
It's the first time on a motion hearing, Judge.
I know all motions calendar are generally in person unless I'm taking a plea.
It's the first motion I've had in Orca, so I'm sorry. I didn't know that.
That's all right. We live and learn. It was reset by Judge.
Yeah, okay, you got it. Okay,
And
buddy.
then wait because they're bringing in, they know they're bringing in a Farsi interpreter.
Okay, buddy, thank you.
Yes, sir.
Yeah, we just did it. All right, thanks. All right.
All right. Mr. Mohsen?
Yes,
Yeah.
ma'am.
You hear me?
Yes, ma'am.
Okay, we are waiting on the interpreter. And so you can mute your phone or silent your phone until we are ready to call your case again.
Okay.
See you.
Thanks so much.
Yeah, so please, if you or your friend or Mr. Glanville, go ahead and mute the iPhone for present time.
Yes, ma'am.
Okay, Ms. Waldrop, this is State versus Janelle Lukens, 21 CR 003-836A. Ms. Lukens was accused of following too closely, driving under the influence of alcohol, and less safe, and driving under the influence of alcohol per se, stemming from an April 23rd, 2019 incident. Ms. Lukens is appearing via Zoom, although we can't see her, and her attorney is George Creel. We're here on a motion to, on their motions in limine, but tell me what's going on, Ms. Waldrop?
Yes, Your Honor, with respect to the motion in limine that defense counsel has filed, first of all, it's improperly filed as a motion in limine. These are constitutional challenges.
Let's go ahead and
Should be.
make sure that my, oh, you can be seated. I think the audio is much better if you're seated.
Okay. First of all, it's improperly filed as a motion in limine, Your Honor. These are constitutional challenges that should be brought up and asserted in a motion to suppress. So what I believe defense counsel to be doing is using the motion in limine, the label of motion in limine, in order to circumvent the time constraints and requirements for filing a motion to suppress. As the court is aware, defense counsel must file a particularized motion to suppress within 10 days of arraignment, whereas a motion in limine can be brought at any time, which is why he's labeled this as a motion in limine. But it is not, it is a motion to suppress. Your Honor, the state would show that the defendant had arraignment on October 7th of 2021, when defense counsel filed a waiver of arraignment and entered a plea of not guilty. And so within 10 days of that date, he had the opportunity to file a particularized motion to suppress, the timely motion to suppress. And he did not do that until filing this motion on July 13th of 2023. So that is 4 years, 2.5 months after arraignment. Based on that, I believe that the court should deny defense counsel's motion to suppress as it has not been timely filed. With respect to discovery, defense counsel has been representing the defendant since this case's inception in Sandy Springs Municipal Court. So he had the opportunity to not only get discovery there, but also, Judge, the state did file into the record bind over materials that included the police report. And that was in October of 2021. So he has had more than enough time to file a particularized motion to suppress. In this case, it is untimely. It is extraordinarily untimely, being 4 years late, and the state would ask that you deny it.
All right, Mr. Creel?
Okay, first of all, a motion to suppress is for tangible evidence. A motion in limine is for testimony, and we're moving to suppress the testimony. There is no drugs that were seized. And so it absolutely is a motion in limine. Further, Your Honor, the state's argument is nonsensical. There's no way, we don't have 10 days from arraignment in Sandy Springs. We have, if there was a motion to suppress and the court was enforcing that rule, it would be 10 days from arraignment in Fulton County State Court. And we have both a plea and bar and a motion in limine. The plea and bar addresses the fact that the state, the UTCs were not file stamped in Sandy Springs, and they were filed 123 days after the statute of limitation ran, not 122 days, which currently the only Court of Appeals case interpreting the statute of limitations is the is that case? The Garrison case, Garrison v. State, which the Court of Appeals issued on July 20th, 2023, where they held that the statute of limitations in a DUI case was extended 122 days. Third, this is a case where pre-Elliott implied consent was read. Ms. Lukens was told that Georgia law required her to take a test, and so she submitted to a blood test, and that was in violation of her constitutional rights to avoid compelled acts, and it coerced her and was not knowing and voluntary as required by Williams. So those are specious arguments at best on the part of the state. Again, this is absolutely a motion in limine, and I lay out very clearly in the predicate language in the motion in limine, the case law that says it is a motion in limine and not a motion to suppress. So that's our position on the case.
All right. I believe that you were trying to suppress the response and the blood test. Would that be correct?
Yeah, the testimony from the blood test.
All right. I'm going to construe this as a motion in limine. I don't find that it's time barred, and this is going to be addressed prior to trial. Is your client seeking a jury trial or a bench trial?
We are currently asking for a jury trial, Judge.
Okay. I'm going to arraign the case, and this is, as you've already filed your motion to suppress, this is going to be deemed to be a motion in limine, which will be addressed briefly prior to the case being addressed at a jury trial. Case management order will issue today. If you plan to file any other motions during the course of this time, please do so, but please understand they will not be addressed at a motions calendar. They will be addressed as a motion in limine prior to trial, and those will be taken care of in a short period of time. There won't be a substantive hearing before trial. Would you like to refile a waiver of arraignment, or would you like me to arraign your case? Your client needs to fix a video before I can arraign the case.
I believe we've already filed a waiver, Judge.
That was in City Court of Sandy Springs.
No. We filed a waiver in State Court.
Okay. Yeah. All right. So case is ready for a jury trial. You will get a court date. FYI, Ms. Lukens, if you're listening, and Mr. Creel, jury trials are in person, not Zoom. So
Yes.
as soon as you get the call for calendar, she will have to make the trip down from Ohio to attend calendar call, and then determine I don't know if we will reach her case on the first day, but we do have few days scheduled for the course of the jury trial. So please be prepared to stay here for more than one day.
Of course, Judge. The notice, I have it pulled up, said the case is set for virtual motions. You may attend virtually or in person. That's why I opted for Zoom. So I'm sorry, I apologize, but I did not.
No problem, no problem. I'm not taking, all I'm saying is that typically our motions calendar in person. But if you can forward that, notice to Monica Redden, her emails on the chat, that would be very helpful.
All right. Thank you, Judge.
All right. Thank you, Mr. Creel. We'll see you at jury trial. Ms. Lukens, please speak to your attorney to make the appropriate travel plans. Thank you.
Thank you.
All right. Motion to get responded to trial. Ms. Waldrop, did you have anyone that needs to be excused from
Yes,
this
Your Honor,
case?
I will.
Okay. Ms. Kurt, Julie Kurt is not present yet. Eduardo Medina, Christopher Howard, attorney Christopher Howard. No sound. Oh, Ms. Waldrop's not here. Okay, we'll wait until.
I can give Miss Julie Kurt a call, by the way. I believe I have her number.
No, not Ms. Kurt, Christopher Howard. Ms. Kurt has indicated she wants us to hold for a report. So her client's on Zoom as Quincy's iPhone. Mr. Willis? Oh, he's talking outside? Is that who's talking to? All right. Is Mr. Willis outside? Mr. Waldrop, did you see Attorney Willis outside?
I did not, Judge, but let me double check.
Judge, I sent you that court notice. May we be excused?
Yes, Mr. Creel. Y'all have a good day, weekend. Thank you.
Take care. Bye-bye.
Bye-bye. Miss Kurt, good morning.
Good morning, Judge. How are you?
I'm fine, thank you. Your client is also on Zoom. Quincy, it's iPhone. Quincy.
And thank you for holding, Judge. I just finally broke down and I'm trying to do 2 Zooms at once. The other one's going quite slow.
You guys are masters of multitasking now. So we had called your case. Let me make sure. Miss Waldrop, are you with the Quincy Novabude or is that Mr. Stevens?
That'd be me, Your Honor.
Okay. All right. This is Quincy Novabude. He is on Zoom and Ms. Kurt is his attorney and she has filed a motion to suppress. And are we ready to move forward, counsel?
Your Honor, it's my understanding that this is a plea agreement, so there will be, unless the defense is moving forward on their motion, and my understanding this we're doing a plea.
It will be a plea. Would that be correct, Ms. Kurt?
All worked out, Judge.
Okay.
Y'all should have the paperwork and we're ready to go.
You have the paperwork, Mr. Stevens, Ms. Redden?
It should have gone through state.orca. I can forward it if you still don't have it.
Could you please?
Yes, Your Honor.
Ms. Redden? All right, Ms. Redden, give me a few moments just to get the paperwork printed up. Mr. Willis, right after I take this plea, we'll be ready to proceed with Chad Zoretic. Am I pronouncing that name right or am I completely butchering it? Okay.
Yeah, sure.
And Mr. Zoretic, you can come and have a seat next to your attorney.
And Your Honor, Mr. Zarek, that's not going to be the plea. That's the Mr. Mahosen. Mr. Zarek that's for the motions.
Yeah, so we're still waiting on an interpreter for Mr. Mahosen. So we're going to proceed with Zoretic and Mr. Willis is representing. Mr. Willis, are you doing the entire motion for the Mr. Shoson's case or are you just holding?
One more time, Your Honor, I missed that.
Are you doing the whole substantive hearing on Shosen Mohose? The interpreter case?
Oh, the interpreter case.
Yeah.
That's a plea that's negotiated.
Oh, it's a negotiated plea. Okay, so I'm waiting on the interpreter unless you all want to waive the interpreter and use his friend.
I would waive the interpreter, Your Honor, if necessary. That's what we plan to do this morning. That's at least what Mr. Hansford told me they were planning to do this morning anyway.
Okay, if you all waive the interpreter, then I won't hold for interpreter.
I'll waive it, Your Honor.
Okay, thank you. Ms. Kurt, you ready? Quincy's Nawabude, please start your video.
Yes, Judge.
All right. This is State versus Quincy Nawabude, case number 21 CR 0055598. Mr. Nawabude was accused of DUI, driving under the influence of alcohol, less safe, and speeding from a December 6, 2020 incident. Mr. Nawabude is present via Zoom along with his counsel, Ms. Julie Kurt. Mr. Nawabude has been advised of his right to remain silent. This is going to be a negotiated plea hearing. Mr. Nawabude, am I pronouncing your name correctly?
Yes, ma'am.
All right, please raise your right hand. Do you solemnly swear and affirm that the testimony you provide for this plea hearing will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you very much. And Mr. Stevens is the prosecutor. Could you please let me know what's the plea offer to what charges?
Yes, Your Honor. Just sent the plea paperwork to Ms. Redden. Give me one moment to pull the case.
Oh, can you put it on microphone, please? Thank you.
Yes, Your Honor.
Thank
I just sent the plea paperwork to, okay, you have it. I'm pulling up the case right now. In terms of the plea agreement, Your Honor, the state is asking Mr. Quincy to plead guilty to the counts of reckless driving and to speeding, and we will be dismissing the DUI, Your Honor.
So you're amending the DUI to reckless driving?
Yes, Your Honor.
Okay. And what is the recommendation for the reckless driving?
For the count one reckless driving, the state's recommendation is 12 months probation, $300 fine, 40 hours of community service, one alcohol and drug evaluation and treatment, one risk reduction program, and one victim impact panel. For the count of speeding, that is just a 12 months probation to run concurrent with the $200 fine, Your Honor.
Ms. Kurt, are those the terms to which your client has agreed? And do you
Correct, Judge.
stipulate to the factual basis, venue, and ID?
And we do stipulate.
Okay. And did your client serve any time in the jail facility at the time of this incident?
He was arrested at the time this offense took place, Judge.
Was it 1 day?
Yes, approximately.
All right, so it'll be 12 months to serve 1 day, credit for time served 1 day. This is a first time DUI? I mean,
Yes,
well,
Judge.
it's not a DUI, so it's reckless driving, so this is not. Okay.
It was a first offense DUI and has now been amended.
All right, thank you. Mr. Nawabude, have you consumed any medication or alcohol today?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anybody forcing you or inducing you to take the plea offer today?
No, ma'am.
If you decide to enter a guilty plea to reckless driving and speeding, understand that that would add points to your driver's record.
Yes, ma'am.
And you understand that if you decide to accept this plea offer, that you would have to give up your right to a trial, to a right to confront your accuser in a court of law, to challenge the evidence and the witnesses brought before you, to be able to present any defenses if you choose to do so, and also to have the state try to prove the original charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
Are you waiving these rights freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to 1 count of reckless driving and 1 count of speeding?
Yes, ma'am.
Well,
Guilty.
I'm sorry. Yeah, guilty.
how do you plead to
Guilty.
1 count of reckless driving and 1 count of speeding?
Guilty.
All right. And Mr. Stevens, on the speeding, what is the speed limit?
Reduced down to what? Your Honor, the charges for speeding going 95 in a 65-mile-an-hour zone. Oh, sorry, 55-mile-an-hour zone.
95 in a 55-mile-per-hour zone.
Yes, Your Honor.
Ms. Kurt, this would be a super speeder violation. So
I'll explain that to my client.
95 in a 55-mile-per-hour zone. Okay. Mr. Nawabude, before I confirm acceptance of your guilty plea, I should have also ascertained that you are pleading guilty to a super speeder violation, 95 miles, speeding at 95 miles per hour in a 55-mile-per-hour zone. That means it is a super speeder. That would add 6 points to your driver's history, and the Georgia Department of Driver Services will send you a separate bill for an additional $200, which will be plus the $200 that I will be imposing as part of my sentence. So that means your total obligation for speeding is $200 fine to the court, and $200 fine to the state of Georgia Department of Driver Services, and $300 fine for reckless driving. Is that your understanding?
Yes, I understand.
And do you accept these terms?
Yes, ma'am. I
All right.
accept.
I'll then accept your guilty plea to reckless driving and the super speeder violation. On the reckless driving is 12 months probation to credit for time served 1 day, credit for time served 1 day. You will pay a $300 fine. You will complete 40 hours of community service with any nonprofit 501c agency that is not a church and not a school. You will complete an alcohol and drug evaluation with a qualified healthcare provider and submit yourself to any treatment or counseling at your expense. In addition to these conditions, you will also complete a risk reduction program and attend one victim impact panel. With the speeding offense, as I've said, the court imposes a $200 fine. You will be on probation to pay that additional $200 fine. As indicated, the Department of Driver Services will send you a separate invoice for an additional $200 fine on the super speeder, which must be paid. Otherwise, you risk your license being suspended. You will report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. You must report before 3 p.m. You will continue to report to probation until all the conditions are completed, and then after that, it will be non-reporting. Do you understand, Mr. Nawabuddin?
I'll be out the country that Thursday. The
I
only
was
issue.
going to say, Judge, he's got a family wedding that Thursday. Could he report before?
When
or
are you
after that?
leaving?
I'll be gone the 28th.
That's a Thursday?
Yes, ma'am.
Yes.
All right, then you report on the 27th. No, not 27th, that's a Wednesday. You report on Tuesday, the 26th, before 3 p.m.
Okay, thank you.
All right, Ms. Kurt, any questions?
Judge, no, thank you very much for holding for my report. I believe that completes our business today.
Yes, thank you.
Thank you very much.
Ms. Kurt, before you leave, could you please check your chat? You got a message from Miss Monica Redden.
Yes, absolutely. Sending it now.
Okay, thank you. All right.
Thank you very much, Judge. May we be?
Willis, I know I promised you next by one more plea to take up, and then we will move on to your case.
I understand, Your Honor.
And I believe that's your plea anyways.
Yes, Your Honor.
Okay. Mr. Nawabuddin, you're free to go. You can reach out to your attorney if you have any questions.
Okay, thank you.
All right. I have a Farah who is about to join the Zoom. And I'm just waiting for her to connect on. All right, Miss Farah, if you can please pull over as soon as possible. I don't know if she can hear me, she's driving. Miss Farah, can you start your video?
Hello,
Yes.
hear
Miss-
me?
Good morning. Are you a Farsi interpreter?
I am. Morning.
Okay. Good morning. I have you stopped driving?
Work somewhere so we can talk. Give me one.
Okay,
Sorry.
no problem.
I just get the assignment, so just
I-
give me one
I understand.
few seconds assignment. So I'm sorry. Pulling back to you.
While we're waiting on interpreter, any response from position 2 to Christopher Howard or Eduardo Medina?
No, Judge, I'll keep reaching out.
Okay.
Otherwise, the state will request a bench warrant.
Okay. Mhm. Yeah, she's on, just waiting for her to pull over.
Okay.
Miss Farah, are you safely parked now?
Okay.
Miss Farah, are you safely parked?
Yes, ma'am.
Okay, may I have your last name, please?
Pernas.
Feranas?
OFOGH. Awful.
Or you can put in the chat with your correct spelling so we have your correct name on the Zoom panel.
Yes.
Okay. And Mr. Glanville, can we change the name on Mr. Shozen's Zoom panel to his full name? It's on the calendar. Sheikh
Doing it now, Judge.
Zinedini. Okay. All right. Miss Farah, do you have the style of the case and the case number?
I am gonna check my email right now.
All right. Mr. Mohsen, please unmute your phone. And Mr. Willis, you're comfortable there to take the plea, but for some reason, there's no video of you. So if you're okay over there, that's
No,
fine.
Judge,
Otherwise,
I
for
don't have
podium,
any
we
case.
have you on video.
Your Honor, I can go to the podium or I can sit here, whatever makes you happy, Your Honor.
I think that would be better so that the client can see you.
Sure.
Yes, no, I'm here.
All right. Ms. Farah, do you have the client's name and case number?
I do have a client name, but I don't have a case number.
Yeah,
I have Mohsen.
Repeat his last name?
Sheikh Dian.
Zainadini.
Zainadine.
Zainadine. Sheikh
Okay.
Zainadine.
Is it okay if I address him as Mr. Mohsen?
Yes, ma'am.
Yes, sir.
Yes, Your Honor.
Okay, he can understand a little bit of English. Okay. Ms. Farah, I'm going to place you under oath.
That's it. No,
Ms. Farah, do you solemnly swear and affirm the testimony you translate will be the truth with no changes or embellishments?
I do.
Thank you. Please advise Mr. Mohsen that you will be interpreting for him. So he needs to wait to listen to you before he responds to the question.
سلام علیکم. من فرح هستم، مترجمتون هستم. لطف کنید اجازه بدید من برای شما ترجمه بکنم و بعد میتونید جوابگو باشید.
متشکرم. بله.
What did he
Okay,
say?
he understand.
His
He
case
said,
number.
okay, I understand.
Thank you. His case number is 21 CR 4085A.
شماره که برای شما امروز دارن، دارین شماره رو 21 سی.
بله. 21
شما امروز برای دادگاهتون، اینو من براتون توی چت براتون تکست میکنم که داشته باشه، نوشته باشه براتون.
متشکرم.
نگران نباشه، براتون میفرستم.
He is accused.
Go ahead.
He is accused of failure to drive on the right side of the roadway and DUI less safe.
شما رو به خاطر اینکه سمت راست و اینکه مثل اینکه یا زیر مشروب خورده بودید، به خاطر این امروز تو دادگاه هستید.
همینطوره. بله.
Yes, that's correct.
It's already been turned in, Your Honor, but I have a copy of it also.
Was it done via DocuSign?
May I take your copy and then make
Yes,
a,
ma'am, of
thank you. He's also got a third charge for reckless, he's also got a third charge for reckless driving.
شما همچنین یه دونه دیگه جریمه شدید به خاطر اینکه رانندگیتون رو مواظب نبودید.
بله بله.
Correct, yes.
He has a right to remain silent. Anything he says can be used against him.
شما میتونید ساکت باشید. هر چیزی که بگین امکان داره که بر ضررتون باشه.
حتما.
He has a right to an attorney, and representing him this morning is Mr. Greg Willis.
شما حق داری که وکیل داشته باشی. امروز هم آقای ولس اینجا هستش.
بله. متشکرم.
Okay, thanks.
In order to proceed with this plea, I need to place him under oath.
قبل از اینکه بخوایم مراحل انجام بدیم شما باید قسم بخورید.
حتما.
Please raise your right hand.
دست راستتون رو بریم بالا.
Do you swear the testimony you provide will be the truth?
شما قول میدین هرچی امروز که میگین درست باشه. درود.
Yes, ma'am.
Yes, ma'am.
All right, the prosecutor is going to tell me what is the recommendation. He may put his hand down.
شما میتونید دستتون رو پایین بذارید. حالا میخوایم گوش کنیم ببینیم پیشنهادشون چی هستش.
Okay. Your Honor, before I begin, does the defense stipulate to the factual basis, venue, and identity?
Yes, we do.
Ms. Farah, did you hear that?
No, ma'am.
We need to speak a little louder. Thank you.
Before the state begins, we would ask the defendant to stipulate to the venue, factual basis, and identity.
And defendant agrees to do that.
میگه قبل از که شروع بکنیم میخوان مشخص کنن که شما همونی هستین که دوباره شما رو از نظر بدون خودتون هستین که الان تو دادگاه هستید.
بله بله.
Okay.
The state will be dismissing the first two charges for vehicle on the wrong side of the roadway and DUI.
دو تا از چیزایی که شما توی سمت راست بودی و اینکه مشروب خورده بود و هر دوتا رو میخوان حذفش بکنن براتون.
بله.
Okay.
And the state is asking for Mr. Mahosen to plead NOLO to the charge of reckless driving.
یه دونه آپشن بهتون میدن که اینو بهتون پیشنهاد میکنن که فقط به خاطر اینکه مواظب نبودید و مراقبت رانندگی نبودید اون رو قبول بکنید.
حتما. بله.
Sure. Yes.
The state's recommended conditions are 12 months to serve, 24 hours. I'll pause here.
به شما دارن برای 1 سال برای 1 سال بعد تحت کاری که اینا میگن تحت دولت باشید.
Credit for time served.
Go ahead.
Credit for time served, 24 hours. The remaining time balance probated.
الان میگن برای 1 سال 24 ساعت ولی امکان داره که بعدا تخفیف بگیرید.
بسیار خوب. بله.
Alright.
A $300 fine, 40 hours of community service.
$300 جریمه و 20 ساعت هم بعد برین جاهای کار بکنین، جای دولتی.
بله.
Okay.
1 risk reduction panel, 1 alcohol drug evaluation and treatment.
برای مشروب باید حتما برین تست بدین که بتونن شما ارزیابی بکنن.
بسیار.
That's fine.
And 1 victim impact panel.
یه دونه دیگه هم جریمه در کنار اینا در کلش میخوام بهتون بدم.
بله.
Okay.
One other thing, Ms. Farah, I want to add is that if he is agreeing to these terms, when he reports to probation, he must bring a friend to help him interpret.
میگه که وقتی شما اینا رو قبول میکنید هر دفعه که میاین باید یه دوستی رو با خودتون بیاری که براتون ترجمه کنه.
حتما.
For sure.
Mr. Willis, does your client agree to these terms? And you've already entered your stipulations.
Your Honor, we do, but we had one other caveat that Mr. Hansford sent me was that there was an agreement to terminate probation once he completed all the special terms and conditions.
Ms. Farah?
میخوان که وکیلتون همه رو قبول کرده ولی میگه که من میخوام که دیگه بعد از اینکه تمام اینا رو انجام داد هیچ تعهدی بعد از اون نداشته باشن.
بله.
I'm
Okay.
checking my email right now in case we already discussed it, Your Honor.
Prosecutor is checking to confirm.
وکیلتون داره ایمیل رو چک میکنه که اینو قبلا برای دادگاه فرستاده.
متشکرم.
تشکر. Thank you.
It was not in the original agreement, but the state has no objection, Your Honor.
Okay, probation will terminate upon completion of all his conditions.
خیلی خوب قبول کردن که وقتی که این تمام اینا انجام شد دیگه برای شما هیچ مورد ممنوعیتی نباشه.
متشکرم. بله.
Thank you so much.
Mr. Motion, have you consumed any medication or alcohol today?
میگه شما امروز دارو یا مشروب مصرف کردید؟
بله، فقط دارو برای فشار خون.
I only take my blood pressure pills.
Okay. Have you been able to understand the proceedings so far?
شما الان متوجه میشین داره چه اتفاقی میفته تو دادگاه؟
دقیقاً.
For sure, yes.
Are you
Completely.
satisfied with your legal services?
شما موافق هستین برای این چیزای قانونی که داره اتفاق میفته؟
بله.
Yes.
Is anyone forcing you to enter a no plea or no contest plea today?
کسی شما رو مجبور کرده که این آپشن رو قبول بکنید؟
نه خیر.
No.
Do you understand that if you enter a no contest plea, you will lose your right to have a trial in this case?
شما میدونید که اگر اینو قبول نکنید شما حق دارید که برین دادگاه.
بله.
Yes.
You will not be able to confront your accuser and challenge the evidence brought against you.
شما حق ندارین کسی که شما رو گرفته یا کسی که به اینا گفته که شما این کار کردید نه حق ندارین برین و باهاش روبرو بشید.
بله.
Okay.
You will not be able to have you will waive your right to have the prosecution try to prove the charges against you beyond a reasonable doubt.
هر چیزی که امروز اتفاق افتاده بعد از این هیچکی نمیتونه شما رو به هیچ چیز دیگه جریمه بکنه.
اوکی. بله.
Okay.
How do you plead to one count of reckless driving?
آیا شما قبول میکنید که این یک دونه کیس رو انجام بدن؟
بله بله.
Yes.
Does he plead no contest? Is that the plea he wants to enter?
I'm sorry.
Yes.
just take it.
Is he pleading no contest? Is that the plea he wants to enter?
شما قبول میکنی که این انجام بدیم الان؟
بله بله.
Yes, yes.
Accept his nolo contendere plea. The sentence is as follows.
قاضی قبول کردش و الان میخوان انجام بدن مراحلش رو.
12
Yes,
months, 12 months to serve 1 day, credit for time served 1 day.
1 سال ساعت 1 ساعت روز 1 ساعت برای سرویسی که انجام میدید.
He will report to probation next Thursday before 3 p.m.
شما هفته دیگه 5 شنبه قبل از ساعت 3 باید برید اونجا و گزارش بدید.
The probation office is at 132 Mitchell Street in downtown Atlanta.
آدرسش هم بهتون الان گفته میچل استریت توی داونتاون اتلانتا هستش.
بسیار.
While on probation, he will pay a $300 fine.
وقتی رفته اونجا $300 باید جریمه بدید.
Do 40 hours of community service at any nonprofit agency which is not a school and not a church.
48 ساعت باید بریم برای جاهای دولتی به غیر از مدرسه و به غیر از کلیسا کار بکنید.
Complete a risk reduction program.
یه دونه برنامه دارم به نام رستایشن، باید حتما اونو کامل بکنید.
Go to a qualified healthcare provider to complete an alcohol and drug evaluation.
باید دکترتون ارزیابی بکنه برای مشروب و موادی که استفاده میکنید.
And submit to any treatment that's required.
و هر درمان دیگه ای که لازم دارید باید انجام بدید.
He also has to attend one victim panel.
یک کلاس دیگه هم هستش که حتما باید اون کلاس رو بگیرید.
I hope they have one in Farsi. Otherwise, he would need the services of a friend to help interpret.
میگه امید دارم که بتونه فارسی باشه، اگه نه باید یه دوستی رو با خودتون ببرید.
Don't forget to report to probation next Thursday before 3 p.m.
یادتون نره فردا باید حتما برید برای پروبیشن که توی داونتاون آتلانتا ازش گزارش بدید قبل از ساعت 3.
And please bring a friend to assist in understanding.
حتما یه دوستی رو با خودتون بیارید که بتونه براتون ترجمه بکنه.
ببخشید فردا Friday or next Thursday.
Next Thursday, September 28.
هفته دیگه پنجشنبه 28 سپتامبر.
Okay.
And thank you for writing it all down. It really helps.
خیلی خوب شد که همه رو نوشتید. واقعا کمک میکنه.
It's a lost art. All right. Mr. Motion, any other questions?
No, ma'am. No.
Okay, thank you, sir. Ms. Farah, thank you very much. I appreciate your time.
Of course, sorry, it was a last minute thing, so.
They always work out. Thank you so much.
Thank you. Have a great day.
You too. Thank you.
خدا نگهدار آقای محسن.
Okay. All right, let's move on to our next case. I already gave you everything else, right? Oh, no, he has his copy back and you have the. Okay, yeah. Mr. Glanville, we can assist him with leaving the Zoom. Ms. Kurt, did you still have another case? Jefferson? Okay. All right. Last but not least, State versus Chad Zaretic, 21 CR 0054348. Mr. Zaretic is present in the courtroom with his counsel, Mr. Gregory Willis, and he was originally charged with DUI, driving under the influence of alcohol per se, driving under the influence of alcohol less safe, and an equipment violation with regards to taillights. Defense has filed a motion to suppress and a motion to take judicial notice of the blood evidence. So are we ready to proceed with the motions?
Your Honor, we have some preliminary matters in regards to discovery we need to take up first before I can make an announcement on that.
Are we? Mr. Stevens, you ready?
Your Honor, the state's ready. Whatever preliminary motions, the defense, there's a large number of motions, so I'll just let the defense start off with whatever he wants to start off with, and the state will respond in kind.
All right, Mr. Wallace, you have the floor, which you can argue from the desk or from the podium, whichever you're comfortable.
Thank you, Your Honor. So, Your Honor, we received discovery in this case yesterday. And obviously this is a very old case. And the discovery I've received does not have a certificate of service on it. And it was my understanding from an email I received from Mr. Stevens that the discovery had been put on some online server at some point in time in 2021, maybe. I don't remember exactly the date, but there's no proof of it being served on me, and I did not receive it. I can't find any of my emails. And of course, there's no certificate of service, so that'd be consistent with the lack of discovery. I also asked again about the videotape for the arresting officer, the body worn camera for Officer Thaxton yesterday. I was told they did not have it yet as of yesterday, I believe. And I haven't gotten an update on where this video is, but we requested this video back in 2020, I believe, in this court. And before that, we requested it in the Alpharetta court. So we're going to request that video be produced this morning. And the only remedy I have, if they do not produce it, is for the court to do an in-camera inspection of that video. That's my only remedy. I'm asking the court, if it's not produced to me, then the court can review it and determine Brady material or not in that videotape. The third issue, Your Honor, is I received word, I think it was Monday or Friday, that Officer Thaxton had been terminated from the Alpharetta Police Department on, and I'm looking at the post record I received, May 13th of 2022. I immediately followed up with an open records request for this exculpatory evidence that the state had not provided and has not provided to me in regards to this case. And the open records request should have been responded to in 72 hours by statute. They finally responded. The Public Safety Department responded and said that they did not contain these documents any longer due to the termination date. I don't even know what that means. I don't know whether it's too old or too recent or what it means, but they sent it to a different department to request the documentation on the personnel file as far as the termination reason.
To what other department would they send it to?
They sent me to Human Resources, I believe. Give me 1 second, Your Honor. Yes, they're telling us to go to Alpharetta HR. So I'm assuming that means Alpharetta Human Resources, Your Honor, different than.
Yes, sir.
So that's where I've been sent, but I have not been provided any of this. We found this out through our own investigation when clearly an officer being terminated is exculpatory evidence. So we have not received that evidence. So there are a number of outstanding things that we need to go forward today.
Mr. Stevens?
Yes, Your Honor.
Start with the information that is been uploaded to the server for defense counsel to retrieve.
Sorry, could you say that again, Your Honor?
Let's start with the prosecution's uploading of evidence to the server.
Yes, Your
where the defense counsel can retrieve it. What happened there?
Yes, Your Honor. So and it's on e-file. It's also in Odyssey. The defendant's counsel can also go down to the clerk of court at any time and request discovery, or request any documents that have been filed in this case. So he has 3 different avenues to request discovery. The discovery was filed on January 7th, 2021. And this was after the defense counsel filed their injury of appearance. So he is already on record. He already has access to these files. Any failure to get these files is purely on defense counsel for not going to the clerk of court. I would ask that the defense use the systems that we all use, and such as e-file, to be able, or the clerk of court to go and get discovery. I have also supplemented that. I have sent him emails and also sent him body cam via email. That is not the first time he's received it. He's received it via e-file, but I supplemented it just in case.
When did you send this?
I supplemented it, I believe yesterday, as the defense counsel mentioned, in terms of the bind over materials, the accusation, the police report, things like that. The body worn cam of Officer Medico was sent on September 15th, on the same day that the prosecution received it, is when I was sent over, and that was in 2023. So the same day we received it, I sent it over. And not only that, but Your Honor, the accusation and the witness list have to be provided within a reasonable time before trial. Scientific reports and any statements by the defendant only need to be required to be sent 10 days before trial. They're not required to be provided 10 days prior to a preliminary hearing or to a pre-trial, just 10 days before trial. And again, regardless of whether or not it's within a certain days, it has been provided. In terms of the video of Officer Thaxton, I have told the defense counsel this. We do not have it. We do not have a copy of that video. It's not in the state's possession. To the state's understanding, such a video does not exist. I believe, from my understanding, is past the retention period, meaning on their servers, it is expired. They've either deleted or it's become corrupted. Whatever it is, Alpharetta no longer has a video to the state's knowledge, and the state is not required to produce evidence that does not have in its possession. I would point the court and defense counsel to 17-16-20 through 23. The state is only required to produce evidence that is within its possession. Finally, whether or not Officer Thaxton's video is necessary in order to proceed in today's hearing. Officer Thaxton's video is all of his statements and all of his interactions with the defendant are recorded on Officer Medico's body cam up until when the Officer Thaxton places him into his police car and drives away. The reason for the stop, the initial conversation with the defendant, the statements made by the defendant, as well as the manifestations and his consent to be fields, all those are on Officer Medico's body cam. So he has enough information to be able to proceed on the body cam itself to be able to proceed. If not, he doesn't need body cam because, again, it's not required by statute to provide body cam. It's all required by statute to have scientific reports, statements made by the defendant, accusation, witness list. And we have Officer Thaxton and Medico here able to testify. He's one of the ones.
I'm sorry, who's here?
Officer Thaxton and Medico, both the officers that were there on that night.
Oh, they're both here.
They're both here, Your Honor.
Okay.
So for those reasons, we would ask that the defense has been given discovery, and if you would like to proceed on these motions today, then when this is ready, proceed, Your Honor.
Mr. Willis, response.
Your Honor, well, first of all, let's just talk about discovery. 17-16-1 says anything in possession of any state agency, whether it's a police department or the GBI, is in possession of the prosecution. So the fact that they don't have, and I keep hearing this argument, I don't know why Pat.
Which evidence do you claim that they have that you haven't received?
The video of Officer Thaxton that is on, there's a report that I received yesterday that says that there's video and audio recording of the incident from
Officer Thaxton's present today?
Correct.
You can question him during the motion to suppress.
How can I possibly question him about?
On the existence of the video? If there isn't one and then you claim there's one, that's going to go to the credibility of the witness. So the motion to dismiss is denied on that grounds. Next one. What's the other issue?
Okay, can I just make a record, Your Honor?
Yeah, go ahead.
So Officer Thaxton has been terminated from that department. How could he possibly speak on the availability or unavailability of a videotape in that department where he no longer is employed?
He allegedly made the video from his body cam. So if he didn't make one, then he didn't make one. He made one, then he made one. But that's something I won't be able to pry into his mind until we have him on secret here and you can question him about that.
Okay, well, I'm asking the court for an in-camera inspection.
That's denied.
Body worn camera.
I've denied it.
Versus Maryland.
I've denied it.
Thank you, Your Honor.
Mhm.
The second issue we have as far as discovery, Rayburn versus the state is the case. 234 Georgia Appeal 482. Can I approach, Your Honor?
Sure. On the Rayburn case? Okay.
Yes, sure. This is a discovery matter that was handled by Jamie Wingler, who was in my office back in 1998. And Your Honor, the state made all the same arguments they're making today. They'd actually had a motion hearing, and also they had the transcript of that hearing produced where the officer testified as it related to the results of the HGN. And the Court of Appeals said that has nothing to do with the state's obligation. The state's obligation is to provide it to the defense. And the state, I think, has acknowledged they have not provided it to me by saying that there are all these other avenues that I can go to get discovery. So under
No, let's correct that sentence. So are you saying the state didn't provide it, or are you saying that was already out there, but they're claiming you could have accessed one of these avenues? So which one is it?
I received an email yesterday with it, Your Honor.
Okay. You received yesterday the evidence yesterday.
The discovery, paper discovery email
Okay.
yesterday, yes.
So are you saying that it was never uploaded on the server or available to you online? I mean, which one is it?
I have no clue.
Okay.
I don't
So
have any.
not knowing one thing or saying they absolutely did not produce it are two entirely different things. So I want to be sure.
Okay, well, let me be sure. They did not produce it to me, so I don't care where they uploaded it to a server. I don't have an obligation under the Rayburn case to go looking for evidence. In the Rayburn case, said there was a transcript even of the evidence. So my point is, I don't care where they put it or where they didn't put it, 'cause it wasn't sent to me. So the problem with the discovery is if it's not produced under 17, 16, 20, 21, 22, and 23, then it has not been given to me. So that's when I say it hasn't been produced to me, I received it yesterday when my motions were filed a few years ago.
Okay. That makes more sense then. Next thing.
Okay, so, and as it relates to the videos, the state's argument is that they're not required to produce them under the statute. They're required to produce them under well, first of all, there are statements on the videotapes, obviously. So there are statements of my client on there. So I do think they need to produce that. And the second thing is the evidence on there is subject to a Brady motion. So I think they absolutely are required to produce videotapes prior to motion hearings. And as it relates to the officers' personnel records, there's been still no answer as to why they have not produced any of this exculpatory evidence as to the determination of this officer from the Alpharetta Police Department. And I don't have that, despite the fact that I've made great efforts to do it and get this evidence. I don't have an obligation to go out and find Brady material. The state has an obligation to give that to me. So I'm entitled to that before we have a hearing today, Your Honor.
All right. With regards to the reasons why Officer Paxson was terminated or the information that surrounding this termination by the Alpharetta Police Department, I don't have one way or another to determine whether it is exculpatory or not. So I'm going to deny the request on that. If that information comes out during the course of examining Officer Paxson on the motion to suppress, then that's going to be given weight to my decision on the motion to suppress. With regards to video that was not produced until yesterday, since it has been produced, the request for any continuances or dismissals of the state's case is denied. And I've already denied the request for an in-camera inspection. With regards to counsel's proposition that it was not sent to me, I'm not certain under the Rayburn case how it was supposed to be sent to you. The state has indicated that they uploaded the information. They have been sending discovery digitally. It is available online to attorneys of record. So the motion to dismiss or deny, to suppress is denied. We are going to proceed with the motion to suppress. You have two officers this morning, Mr. Stevens?
And toxicologist, Your Honor.
All right, and the so 3 witnesses. Mr. Willis, would you like an opportunity to speak to prosecution and all the officers or review anything before we begin with the hearing?
Yes, Your Honor. I want to review the videotape of the body worn camera, Officer Paxton.
I don't know if there's one. Is there one?
Your Honor, if I could make a couple things very clear for the record. First, in terms of, I believe Your Honor said that the video wasn't produced until yesterday. I've resent the bind over materials, the video itself, and I have the export audit log was produced on September 15th, 2023, on the same day the state received it. So he's had the video for longer than just yesterday, and it's
Just clarify what video you're talking about.
I will, please don't interrupt me, if I would appreciate that. The video of body cam and dash cam of Officer Medico. And another thing we want to put on the record is this video of Officer Saxon. As I've said, the state has no knowledge that such a video exists. We have inquired it to the agency. To our knowledge, it is past the retention period. It no longer exists. There is no way to retrieve it. There is nothing to give. And finally, as Your Honor already put out, that he can't prove that's Brady because he doesn't know what's on the video, so we can't claim that's Brady. And not only that, but he has to show that we've exercised bad faith. And he tried to argue 17-6-1. That applies to felonies, not to misdemeanors.
All right.
Thank you, Your Honor.
Are you planning to show any video of anything regarding this case by Officer Paxton?
No.
Is it Paxton or Paxton?
Paxton?
Paxton, okay, no? All right, motion to review any video is by Officer Paxton is denied. We have the video of Officer Medico, right?
Yes, Your Honor, and Officer Thaxton is on the video. So
Okay.
we're having the video that is going to be credited by Medico and Officer Thaxton as being a fair and accurate depiction of what
Well,
happened.
Officer Medico can do that, I gather. So anything else, Mr. Willis?
Yes, Your Honor, I'm asking for an in-camera inspection by the court in regards to the personnel records and the legal position of the state is that anything they don't produce, then we have to show it's exculpatory, and otherwise you don't do an in-camera inspection. That is not even remotely close to the standard. There would be no point of having a Brady motion if that was the standard. They could not produce evidence and they could say, well, they can't prove what's on it, Judge. You don't have to do an in-camera inspection. That is not true. If you're asking for a motion to dismiss based on a Brady violation, if you're asking for a lot of things based on a Brady violation as it relates to a trial remedy, that is 100% correct. As it relates to evidence, I have a right to ask the court for an in-camera inspection. If there's a disagreement as far as what's on the videotape or what's in the personnel files of Officer Thaxton, the remedy that this court must give us is an in-camera inspection after the state produces this evidence.
What am I inspecting?
You're inspecting the personnel records of Officer Thaxton and you're inspecting the body worn camera video of Officer Thaxton.
Denied.
Thank you, Your Honor.
So do you need any additional time to review anything else?
Do you mean today or do you mean to get
No,
this evidence?
today, right now.
Well, I need more.
Everything else that's been denied. Anything else over and above that? No? Yes?
Well, I definitely need more time to get this evidence, Your Honor, and I'll be happy to go to Alpharetta myself and get it since the state's not going to produce it.
You're here on a motion to suppress, right?
Yes, Your Honor.
And you've already been sent evidence of whatever they sent you yesterday. I wasn't privy to that email. So whatever they sent you yesterday or prior to that, you all already looked at that. We're moving on a motion to suppress.
Thank you, Your Honor.
So the state's going to call their first witness.
Your Honor, I'll do the motion to suppress if the defense is moving forward on the motion to suppress.
We are moving forward.
I would let them make the argument of what they're trying to suppress, given the number of motions. I'd like to know what they're trying to suppress, Your Honor.
Fair enough. Mr. Willis, let's go through your motion and let us know what you are touching on right now.
First of all, Your Honor, I'd like to invoke the rule of sequestration.
We will.
Thank you, Your Honor. We're challenging the articulable suspicion for the stop.
Mhm.
We're challenging the continued unlawful detention of my client. We're challenging the qualifications of Officer Medico and Fruden to detain my client. Probable cause to make an arrest. The lack of Miranda warnings as far as statements made by my client. The voluntariness of the field sobriety evaluations. The accuracy of the implied consent warning. The admissibility of the blood test. Qualifications of the blood drawer. The proper administration of the blood test. Proper technique to draw the blood. The reasonableness of the blood demand itself under the Birchfield case. And we're asking for a Daubert hearing on, or 24/7/702 hearing on the blood test, HGN, walk and turn, and one leg stand. And that is the extent of my motion today, Your Honor.
All right. So with regards to articulable suspicion, the predicate supporting probable cause to arrest Mr. Zoretic for DUI the admissibility of his statements, the admissibility of the implied consent as it was administered, and admissibility of the results of the state administered blood test.
And, oh, sorry.
Yeah, you missed a few there. You want me to go back over?
I'm just lumping it all on because it's all under the same umbrella. The Daubert analysis, the voluntariness of the field sobriety test, the admissibility, all that are predicates to probable cause to arrest.
And qualification of the blood drawer.
The that goes to the admissibility of the blood and state administered blood
Okay.
test.
And the unlawful detention of my client from the
Probable,
stop. all the way-
probable cause to arrest him.
Your Honor, real fast before we get into the state's response, I believe the opposing counsel mentioned the Daubert in regards not only to the blood test, but also to HGN and to the field sobriety test. I can look through the motion again, but from my understanding, he did not follow a Daubert hearing. He articulated Harper, I believe, in regards to HGN, not Daubert.
You can raise that as an objection during the course of the hearing.
Yes, Your Honor. In regards to the number of motions to suppress from reasonable articulable suspicion, probable cause, the state will be calling Officer Medico, Officer Thaxton, as well as providing a certificate of the blood drawer, as well as the testimony of toxicologist Carla Turner, in order to show, one, that there was reasonable articulable suspicion for the traffic violation, that there was a reasonable articulable suspicion to detain him based off the manifestations that were seen, probable cause to arrest based off the field sobriety and the admissions the defendant made. And those admissions were made voluntarily. They were not coerced. They wasn't required to do a Miranda warning because it was not to a level of, there was no arrest until after field sobrieties were done. And he was not being unlawfully detained while he was doing the FSTs. And then in regards to the qualifications, both officers will testify to their qualifications and training, as well as we again have the toxicologist here to testify as an expert in regards to the blood draw. Thank
Okay,
you.
thank you. I have an officer standing there. Your name, sir? Medical. All right. Is that your first witness?
Your Honor, before we get into the witnesses, the state would like to ask you to take judicial notice in terms of the Daubert, not applied to the HGN and the HGN, the field sobriety test. We would file a separate judicial notice because again, that wasn't what was originally in the motion to suppress. However, the motion to suppress related to Daubert and the blood test, the state has filed a request for you to take judicial notice. If Your Honor would take a moment for me to go through some of the reasons why. First is that under 702D, upon a motion of the party, the court may hold a pretrial hearing to determine whether or not a witness qualifies as an expert and whether the expert testimony satisfies the subsections of A and B of the code section. So you are not required to have a pretrial hearing in regards to Daubert. It is entirely up to you if you would like to take judicial notice. And the reasons why you should take judicial notice are multiple. First off is that the 40-6-392, which has been codified by the Georgia State Legislature, goes into what is required in order to have a valid blood chemical test, blood, breath, or urine. I apologize. It goes into the testing that must be done, who has the permits, who is allowed to do the draw, the GBI and Division of Forensic Sciences approvals and the procedures. So the legislature has already put on extensive codified section on what qualifies as a valid chemical test. Next, a number of other courts have already taken judicial notice of this. That includes both ones in Georgia on a federal level and other states. In Georgia, there was State of Georgia versus Queen. That is a state court case out of Cherokee County from 2023. And that one, the judge took judicial notice of the gas chromatology.
I'm sorry, was that Exhibit A? I've got Exhibit.
Yes, Your Honor.
Okay.
Yes, it's Exhibit A, and I apologize. It's about a 16-page
Excuse me, Mr. Jacob, excuse me, Your Honor. The court reporter needs you to slow down if possible, both sides, if you all could speak slower.
I apologize.
No worries, thank you.
So on Exhibit A of the notice of state request for you to take judicial notice, you'll see that order granting the state's motion limiting to admit the blood toxicology, and that judge examined the procedures, reliable principles and methods of GBI testing as it relates to blood. He did so under the statute of 40-6-392, as I discussed. And then he also did it under Daubert. They had a Daubert hearing just in case because.
Please slow down.
I apologize.
Thank you.
You can have a seat, Mr. Stevens, and bring that microphone down as close as possible to you. Do you need some water?
No, Your Honor.
Okay, go ahead.
So in state of Georgia v. Queen, the judge had a Daubert hearing as it relates to 702. And he also examined the toxicology under 40-6-392. Under both statutes, they had a lengthy pretrial hearing, and they determined that the blood toxicology under gas chromatography, I can spell that out for the court.
Oh, I know, I'm reading it as you go along.
One has been practiced and been admitted in Georgia courts for almost over 50 years. It has been a widely practiced. There was two experts that came in to testify as to the extensiveness of the testing that occurs, how many other states use the same testing, how reliable it is. And for that reason, the judge in Cherokee County ruled that it was admissible under Daubert. Then the next Georgia case, which was the state of Athens Clarke County out of 2022. And that should be Exhibit B, Your Honor.
So let me just cut through the chase, Mr. Stevens. You have given me two orders in which there were extensive pretrial hearings, and then the judge basically said he doesn't find any Daubert violations, that these tests do pass scientific muster. So just because they found it pursuant to their hearing, why should I take judicial notice just because their hearings were legit?
Yes, Your Honor. So not only has two other state court judges, but also in the federal courts in the 11th Circuit of Greer v. Ivy. That's 2022 U.S. App Lexus 2043. In another Ledbetter v. Blair Corps, 2012 U.S. District, Middle District of Alabama, 2012. In Six Killer v. Patton, the 2016 U.S. District, Lexus 185781, and the U.S. District Court for the Western District of Oklahoma. And then finally, other states have also admitted it in State v. Barton, and that's a Tennessee appellate court, in Shard v. State. It's a 2017 case out of Texas, who was reaffirming the decision of Beckingham v. State. And then also another criminal Texas appellate court in Kelly v. State. And the reason why, Your Honor, that you should be using these as reasons to take judicial notice is because under OCGA 702F is the intent of the legislator that in all proceedings, the court of the state of Georgia not be viewed as an open to expert evidence that would not be admissible in other states. Therefore, in interpreting and applying this code section, the courts of this state may draw from the opinions of the United States Supreme Court, as well as other cases in other federal courts applying the standards announced under United States Supreme Court cases in Daubert, in General Electric, and in Kumho Tire. So you have a number of other states, you have a number of other federal courts, and you have other courts in Georgia that have all accepted that this toxicology principle of the methods, that gas chromatography is a widely practiced, reliable, scientific, beyond really question, as well as the Georgia Bureau of Investigations
who in the state of Georgia determines what the policies are used in order to determine that these results for the blood are valid. So because you have other courts and other states, and other federal things, that's why the state is asking you to take judicial notice, Your Honor.
All right. Mr. Willis, brief response to why I should not take judicial notice of whether the procedures required by law should be found at fault.
Your Honor, the order in regards to James Parker, which is Exhibit B, that involves enzymatic blood testing at a hospital. There's no bearing whatsoever in regards to this case. Second of all, the state produced witnesses to testify about that evidence to determine whether it was accurate or not and reliable. So the state laid the proper foundation in that case. In the Queen case, that's kind of interesting because that's a nullity, Your Honor. That decision, that order was signed on January 6th of 2023. Mr. Queen had been acquitted in December of 2022. So the jury heard the blood evidence, acquitted him in about a month before that order was signed. I'm not even understanding why Judge Jordan wrote that order, except for, I guess, the prosecution may have wanted to order for this purpose because the case had already been resolved and the defendant was not guilty. And the reason I know that is because I was late to a conference. Mr. Hawkins and I both spoke at a conference in December. I think it was 2nd or 3rd or 4th, but it was definitely in the first 10 days of December. And he and I were both late. We had to swap out speakers because Mr. Hawkins had got a not guilty verdict in regards to the Queen case, and I was there late from an ALS hearing. So I know for a fact that this order was written a month after the case had already been closed to a disposition. But Your Honor, I think it's appropriate under the new standard in Georgia. It used to be the Harper standard. Of course, the court knows that. It changed to the Dauber standard, and now the state's got to lay a foundation until the appellate courts have accepted and adopted these arguments by the state. So I'd ask the court to have a hearing in regards to the filter body evaluation, the blood drawing techniques, and also the proper administration of the blood test itself.
The motion to suppress, I'm going to reserve ruling on taking judicial notice. The motion to suppress is going to go to the issue of probable cause for the arrest and the scope and the intensity of the depth of how much we're going to investigate. The techniques used to determine probable cause is going to be reserved by the court. I'm not going to go into an in-depth analysis of whether particular techniques are acceptable under Daubert. That is going to be subject to the weight of the trial fact. But at this juncture, the only issue I want to determine is whether there is sufficient probable cause for this case to go on to trial. All right? So at this juncture, I am reserving ruling on the motion to take judicial notice. And I'm going to ask you all very briefly, do you want to make an opening statement for your motion to suppress? Otherwise, I'm ready to go straight to the evidence. Because I'm really eager to find out what happened in this case.
I would let the defense decide to go first and the state would make an opening statement.
Mr. Willis, do you want to make an opening statement?
I'm going to waive opening.
All right. Mr. Stevens?
Did he say he was making an opening statement?
He's waiving.
Okay, I'll waive, Your Honor, and we'll just
All
go
right.
into it.
Officer is Officer Medico the first witness? All right, sir, if you'd like to stroll down and have a seat right here, please. Thank you very much. And Deputy, we need to probably shut the door if were the other witnesses out there, the toxicologist?
He's out there to the left.
All right, we do have a TV outside that broadcasts what's going on in the courtroom, but I don't believe that's audio.
There was audio on that TV a few minutes ago, Your Honor.
There was?
There was about a.
I believe there was during the.
All right, then we, Mr. Glanville, we have to stop the live stream, please, and also switch off the TV. Oh, close, take the, what's the panel called for the TV